So joining us now is Mr. Adamson Adeboro, who is a senior advocate of Nigeria, to discuss some of these matters. Good morning. Thank you for coming on today.
Good morning.
Well, the NJC says public participation in appointment of judges is working. So I know there might be some skeptics about, how do we really say that that is working?
The issue of whether there's problem in the judiciary is no longer an issue of debate. It's an issue that has been admitted. And if you recall, when the current CJN was being screened at the National Assembly, he did say that it is not, all is not well with the judiciary. In other words, it's just to say that, oh, there's a problem, we acknowledge there's a problem, we admit it. But we will take a bold step to ensure that we tackle it. And she promised a far-reaching reforms in the judiciary. And part of it is what we are seeing by saying that, look, the issue of appointment of judicial officers will be made public, just like the way the appointment of Senior Advocate of Nigeria is. That let the public have a say. In other words, if somebody is shortlisted to be appointed as judicial officer, then the public can make comment, whether negatively or positively. So this is a welcoming development. This is the first time this is done. And, you know, when it came, a lot of people expressed skepticism that, oh, we only hear all this. Will it happen?
That's when it was said?
That was when the CJN promised that the appointment of judicial officers will be made public. Because, you know, the general notion in Nigeria is that, oh, it's now, appointment of judges is now an exclusive reserve of the lawyers, of whether the judicial officers who are in high rank or governors of the high-placed persons in Nigeria. But we don't promise that, don't worry. We're going to be fair, so that you will see it's going to be transparent. And today, we have seen what is happening. And first of all, you see some of them, of recent, were read in the news, how some people were filtered out as a result of petition against their candidations. And as we speak, there is one going on, the elevation of judges from to the Court of Appeal. And that has been made public. Now, people have been invited to make their comments, whether positively or negatively, about the conditions of those that are to be elevated to the Court of Appeal.
Do we know how many candidates were screened out as a result of the petitions from the public?
Yeah, I cannot be too certain here, but it's a large number. Because out of about something of them, only 14 or so were eventually taken.
Okay,
but a lot of them had issue. One particularly was alleged to have taken a bribe of 1 million naira. And because of that, somebody who had taken a bribe is a dangerous species. If you allow that person to sit as a judicial officer, and he was filtered out. So
what happened in that case? Is it just going to stop at with the allegation, or are they going to?
No, it's definitely there'll be investigation. You know, you see, our system be what we hear. Anybody can write a petition out of vendetta to say, oh, I'm going to stop you.
Yeah.
So if the authorities receive such petition, they will confirm the veracity of the information.
So what's the criteria?
The principle of fair hearing will be given to the party.
So what's the criteria to filtering people out, especially if you could predicate that based on what you just said, that there could be fictitious petitions?
Yeah. You see, remember that this is not a one-man show.
Yeah.
It's a group of persons who will sit on those petitions to filter them, to look at those petitions to see, oh, then perhaps invite the affected person to put or to defend himself. This is a petition against you. What's your take on it? So, you know, otherwise you breach the principle of audio attendant party. Listen to the other party. You must hear the other party before you take a decision. So I believe that should be done.
So were there any published anonymized petition so that the public can actually see that really and truly these kind of things came through?
That will not be made public. That's the business.
Well, no, that's why I say anonymized.
That can be suggested to the council, NJC.
Okay.
But as of today, we don't know how the whole procedure. It's an internal thing that is conscripted to them. So what is made public is what we are saying here. So what's the method they adopted? But what I know is that there is a principle in law that when there's an allegation against a person, that person must be given the right to be heard. So, if that is not done, then it's a violation of his fundamental rights.
So how do we draw the line between making these appointments maybe like a popularity contest rather than a merit-based system? Because they could just flow into each other.
No, I don't believe in popularity concept.
No, I mean, it could eventually, perhaps, an unintended consequence of what they are trying to do, to achieve.
I don't believe that. You see, to me, it should be based on merit. In those days, lawyers who go to argue before a court can even be nominated based on that alone. Though I've seen the performance of this man, why can't he be appointed? So, to me, appointment as a judicial officer should be on merit, purely. No extraneous factors should be put in. If you merit it, irrespective of where you come from, you should be given. Whether you are the son of the president, you are the son of CJN, or whoever you may be, as soon you are, once you are qualified, then you should be given.
We have heard several times, you alluded to it in passing, when you say there was a petition that one of them was said to have collected a bribe of 1 million naira. But we hear that often, that some of them actually collect way more than that to determine different cases. So, is there any attempt to actually make sure that, look, this allegation cannot be swept under the carpet? Yes, this can be a one-off, but let us get back to scrutinizing the process and see if it's actually going on much more than we think in the judiciary.
You see, anybody can make any allegation. But ability to substantiate your allegation is what is key here. I can sit down here and say, oh, Mr. Shibali said this and that. Then report it to the authority, you have said so. You must be able, or I must be able, to prove what I've alleged. Now, as far as I'm concerned, if you allege that a particular judge is corrupt, you should be good enough to report that judge. And there's a mechanism in place that once a judicial officer has heard that there are procedures to be followed, you write a petition, you verify, you file the affidavit of verification to verify what you have stated, that you are not writing a frivolous application. And that application will be considered on the merit. And once you are correct, then the appropriate action will be meted out.
As a practitioner yourself, have you not heard that allegation before?
There are several allegations. That's what I'm saying. But if you make you are making an allegation, and just to say, oh, this, what I'm saying is you must be able to prove it. Otherwise, anybody can.
Yeah, I get the point.
Rise up and write any petition against anybody.
You, when you hear them?
Yeah.
Because I know you heard them not more than once, several times.
Several.
So do you dismiss them with a wave of hand?
Why should I dismiss? What I'm saying is, it is what I've experienced.
The bribery allegation?
It is what I've experienced I can't say. What I've not experienced, I can't come here and be saying it. So if somebody has said it, it means that person has experienced it personally. So that person must be able to prove it. That's what I'm saying.
What is the mechanism to prove some of these things? What are the procedures?
The procedure is clear. You have an encounter. And what you take a step to say, oh, this also judge took bribe from me. And you write a petition to NJC.
But how do I report that if the law says both the giver and the taker will be culpable?
So who is to be blamed here? So the two of you are at fault. You see, that is the problem.
Yeah,
the judiciary cannot be in isolation of the society. If the society is rotten, if the society is bad.
That may be the case.
That is why the CJN has come up to say, look, we are going to satisfy the judiciary. Yeah. We are leading by example.
Several CJNs have made that comment. Yet you still hear this kind of allegations. But isn't that...
But this one is taking steps, and you have seen it. And some of the past CJN have done it, and we have seen the evidence.
We have even heard people say that to even get your cases listed in courts, they have to sort themselves.
This is part of the reform going on under the new leadership of the Supreme Court. To say, no, the case management, the Supreme Court now, is now harmonized, unlike before. So you don't just because if you file a case today, they call your case maybe in the next 2 months. Why a case of have been filed since 2020 is still pending. They said, no, we don't want that. We want to systematically, arrange ourselves and do it accordingly. So it's an issue of time. So we'll give the CJN time to do what she has commenced.
How much time are we going to
No, it's working. That's it. Don't go to the Supreme Court anyhow. This day you can't get dates like before, that people can just go there, do whatever they want and get dates in one of time. But today, you follow procedure. Also, and this entire system has been now harmonized, and even digitized. That's to show you that we are moving on.
In other words, how do people notice and see this? How does this reflect on the judgments that have been delivered? These changes you say has happened now. Because usually, the CCA cases spend a lot of time in courts.
Yes. Nobody is saying that we have a perfect system now. Nobody is saying that. I won't come here and say that we have a perfect system. But I'm saying that gradually, we are resolving our problems. We are getting to the promised land. But as of today, we see, of course, we see have cases in the Supreme Court that have been there for years. Still there. Nobody will tell you that, that's not that we are in Eldorado. We have arrived. Nobody's saying that. But we are saying that, you see, the entire system has become so bad that one person cannot resolve the whole problem. The current CJN, God forbid, that you be able to resolve the entire problem in the judiciary. But once a foundation is laid, the subsequent CJN will follow. And there we have a track record, a working system that you cannot even close your eyes to when you become a CJN. So that is the issue. The ability to take the decision, the ability to start, is what we are talking here.
So are you saying that these measures that have been put in place will ultimately have its impact to the extent that cases will not be that long even at the Supreme Court?
Of course, but we will go further. You see, some of us have advocated that, look, some of the cases in the Supreme Court have no business being there. For example, divorce, matrimonial matters, what is it doing in the Supreme Court, and some other matters like that. You see, but for you to do that, you need a law. Supreme Court actions or procedures are product of law. So we need to go to the National Assembly to amend the Supreme Court part to limit the division of the Supreme Court to certain matters, just like we have in election petition. When you talk about State House Assembly, House of Reps, Senate, at the end has Court of Appeal. So those are the system that we have to, it's one step after the other. You cannot just put the whole thing at the same time to get it resolved.
Is it going to be limited to just laws, or they will have to set up probably regional Supreme Courts or something to ensure that the Supreme Court is not burdened with cases like this? Some have suggested land matters can go to regional Supreme Court. The ones who suggested can go to regional cases, but at the federal level, there should be specific cases there.
You see, I don't share that opinion. Why I don't share that opinion is because we have Court of Appeals. Okay, in all the regions and that deal with all this matter, and whoever is aggrieved with the Court of Appeal decision in the matter that constitutionally there is a right to appeal to the Supreme Court, can go to the Supreme Court. But my own position, my own belief is that we limit number of matters or the certain matters that can go to the Supreme Court. Once we get that done, then the docket, the filing docket of the Supreme Court will reduce drastically. So the issue of regional Supreme Court, I don't share that opinion. I don't.
So in terms of these changes now, is it stipulated in the laws or somewhere that this is here to stay, so that not when another CJN comes, the person comes up with their own method of doing things?
I've told you. You see, the powers of NJC is embedded in the Constitution. It's a constitutional matter. So if the head of the Supreme Court has come to this is how I want it done, it becomes a convention, become a practice. So as it goes on, then the subsequent CJN can follow suit. But I'm saying that the continuous adoption of what is happening is what is material here. Oh, this standard has been laid. Let's follow this standard. No, but as per the power of NJC, it's not the CGN that is doing that. It's in conjunction with others who constitute or comprise the NJC.
You know, when the part about corruption in the judiciary, it's a sore thumb, whether it's an allegation or not. But if it keeps coming up time and again, and people run away with that impression, you know that there is a challenge. Should we leave it to probably the NJC, or should we have some sort of independent body to look at these matters? Because it won't be easy for somebody who says, from listing your cases, you have to sort out. From getting your judgment delivered, you have to sort out. From getting dates for your cases to come up, you have to do something about that. So if somebody is faced with all that hurdle, they won't go and report themselves. Say, look, I had no choice. I had to give this to make sure this is done. So if there's an independent body to look at these matters, somehow they may have confidence in that body, as opposed to just saying, look, how do we even know the NJC will not perhaps cater to what the authorities want?
You yourself, you said here clearly, both the giver and taker have violated the law. If that's the case, see, the approach is simple. If you go to a court and somebody is asking for money outside the prescribed fees, you say no, stand your ground and say no. That's how to make the system work.
But those that have said no, yes, they've seen their cases be there for decades.
And that is why we are telling you, for instance now, that all these things are being looked into. It will not take, it's not something that just do overnight. You have to put a system in place to correct those anomalies, to see what we can do, that you don't even have to go and meet anybody. You don't need to go and see anybody before your case is listed. That's the system we're talking about here. That's part of the reform. So once you can get that done, then all this issue we are talking about, you see, in advanced countries, you don't even have contact with them there. So
yeah, but there's somebody that still imputes those things now. So that human element, that human interface, is still a challenge.
No, say Nigeria factor.
It's not even Nigeria.
It's our value system.
It's not even Nigeria. There's still Nigerians who do the right things all the time.
Thank God. So it's the value system. If your value system has collapsed, then who are you blaming? Is it only judiciary that has this kind of problem? It's all the segment of the society. Go to anywhere, it's the same problem. But even judiciary on its own, out of the three arms of government, it's only judiciary where they set up the mechanism to correct themselves, to punish all the hailing officers or those that can be apprehended. So, do you have that in executive? Do you have that in legislative arm? So that's the issue we're talking about.
They don't call themselves the noble profession.
That's why we're noble.
That's why
we're leading by example.
That's why you can't compare that arm with other arms. That arm has to stand out.
It's a work in progress. That's what I'm telling you. It's a work in progress. And I want Nigeria to have, so that we can restore the confidence of judiciary in the public.
But what happens? Is there any mechanism, for instance, if people look at a particular judge delivering a certain judgment, and I know you might have heard of the previous cases where a judge is really angry and delivers judgment, and it really comes across as though the judge is delivering this judgment based on anger in court, and justice is not seen to have been done, even though the judge thinks that justice has been done. Does the bar look at that? Does the NJC look at that and say, wait a minute, something seems to have been off here?
Do you know that we have a hierarchy of courts? If, for instance, you go to high court and you see the countenance of the judge, and perhaps it's not reflected in the judgment, that's the essence of appeal. And if you call the appellate court to review the evidence as extrapolated in the judgment, perhaps that judgment can be set aside based on, because judgment must not be based on speculation. It has to be based on the evidence, the fact before the court, the document before the court, the evidence led before the court.
As we wind down, I've been trying to remember the name. I hope I don't get it wrong when I say this. I don't know if it was Justice Wite at the point recently. I think it was in Malami's case. And he said, don't approach me. I am unapproachable. If you do certain things, it was him, right? Yes. And he said, don't you dare. So for a judge to go that far to say that, doesn't that buttress some of those things that people you may have heard saying, look, even senior lawyers approach judges on behalf of their clients to tamper justice and maybe look the other way. These are pointers, aren't they?
You see, that is exactly what I'm saying here. It depends on individual. If you don't want to be compromised, you stand your ground. Nigeria judiciary.
The way the judge stood his ground.
Yes.
So is that bad? To approach a judge?
No. What right have you to approach the judge? Once the court is on you, once the judge is sitting on your case, you don't have any communication with him.
Yeah, but it happens. That's why you have to say that.
This is what I'm saying, sir. This profession, Nigeria profession, at a point, was one of the most enviable judiciary in the world.
At a point.
At a point. But it plummeted. And that is concerned everybody that, oh, look, this is not what we were. How do we resolve the problem? In those days, even in the military era, you can see some judges, they will stand their ground. We have seen those who thrown in the tower because they could not be compromised. And they will say they will not succumb. The judiciary must be independent. So, and that is the essence of the reform we are talking about. Who do you put there? What criteria do you follow in putting that person there? Will it be a person that will be compromised? Or that will shaking out when at the side of the little...
Many are looking to see, will that day ever come where either a chief judge or a CJN will look their appointer in the eye and deliver judgment no matter whose ox is gored?
It is happening.
We saw in Kenya, but we haven't seen it in Nigeria before,
because it's not
where
a
president is sacked as a result of election malpractice. We've never seen it here before.
Because if there's no reason to do that, if there's a reason to do that, I know that we have some courageous judges who will do that. Don't take it, don't generalize the whole thing. There are some outstanding judges, brilliant judges in Nigeria.
But there are some
courageous.
Of course there are. I mean,
so they are there. So
the
bad, and that is why.
But there are several bad eggs as well.
There what?
There are several bad eggs.
Several bad eggs, and that is the extent of the reform. I say, look, once we identify them, get them out. And that's what the CJ is doing.
All right, elections are approaching, so these allegations will come up again. So we're hoping that these reforms will stand the test of time with those and then wipe it out so that people can indeed see that justice is not just done, but seen to have been done.
The election is almost there. In fact, from this year, the election matters will go to court.
Yeah.
And I know the judiciary will be in the eyes of the public.
I tell you.
So basically, we'll see whether the reform is working, or whether anything is done or it is not done, and what is the effect. We'll begin to see.
All right. Well, thank you for coming.
But the most important thing is, if you see and close your eyes, you have no right to complain. Then again, if you participate, remember, you are a co-accomplice. Then you go together.
Mr. Adamson Adeworo, Senior Advocate of Nigeria, thank you for your time this morning.